Well, good morning, everyone. Welcome to the New Hampshire Tech Alliance HR Exchange, our December meeting. My name is Jim Reedy, and this is Sheehan Finney. And we are thrilled to host this HR Exchange this morning. And it's our annual event. And our annual event is to the top 10 wage and hour violations in New Hampshire and hopefully how to avoid them. This is our top 10 list that, we've done for many years. And every year it changes a bit. It changes based on the activity from our friends at the New Hampshire Department of Labor, who were helpful in providing this information to us this morning. But before we get started, I'd like to talk a little bit about the HR Exchange. So the HR Exchange is, again, one of the many benefits offered by the New Hampshire Tech Alliance. And you do not have to be a tech company to be members. But we encourage you to become members, and lots of there's the Entrepreneurial Forum, the MIT Forum, and lots of others for startups or for established businesses of all types and sizes. But this is the HR Exchange. And again, all types and sizes of workplaces, and we focus on workplace issues. And next month, we will be talking about financial wellness. Now, is that for your workplace. It could also just simply be for your employees. And it deals with, last year we did a similar program in January. So fresh start in the new year, looking at your financial well-being. And it's the folks from Boston Wealth Management will be joining us. That's on January 11th. On February 8th, it's a program we typically do in February and tied in part to Valentine's Day, but also just a reminder for all employers out there. February 8th, policies and preventive measures to avoid sex harassment in the workplace. And that will be Jen Meckel will be joining us for that program as a presenter. And in March 8th, and yes, it will be here before you know it, review of legal issues when employees work remotely in other states. And COVID was, of course, the prime driver and a lot of people working remotely. But there are a lot of legal issues that arise when you've got, say, someone here in New Hampshire, living in Massachusetts, working remotely there for the New Hampshire employer, or elsewhere for that matter, and whether those state laws, where they domicile, where they live and work, whether those apply. And in particular, we're looking at everything from tax issues to paid leave issues and so on. So, and that will be, Karen Whitley will be doing that presentation. But this morning, we're going to be talking about the top 10 list of wage and hour violations in New Hampshire. It's the 2022 list, and how to avoid them, hopefully, in 2023. And I will tell you, as you look at this picture, my wife said when she saw me, we were on a flight last week, and I'm working on my laptop, and she saw the picture, and she said, "Oh, is that you?" No, that's not me. That is our frowning Santa. So, in this presentation, for those that haven't been a part of this before, we're going to review the enforcement activity from our friends at the New Hampshire Department of Labor, and it will be wage hearings, inspections, and penalty assessments. And in particular, focusing on what we call the naughty list, the pitfalls of non-compliance with state wage laws and how to avoid them. Those are significant and expensive pitfalls, as we'll discuss. And it was a busy year for them. And I want to sort of pause here for a second and talk about that. The state agency, New Hampshire Department of Labor, they enforce protective statutes. What are we looking at here? We're looking at workers' comp. We're looking at wage and hour. We're looking at safety issues, general safety issues beyond workers' comp. Those inspectors follow what's called protective statutes. And the protective statutes are designed just like that, to protect the employees. Does that mean they're not employer friendly? No, they can be good and decent, and they are. The inspectors are, generally speaking, very civil, very businesslike. But what I want to focus on here is COVID. And I know you're probably tired of hearing that, but COVID did play a role in the wage and hour violations, at least as they were found in recent years. During the last 2 years, a lot of these inspections were done virtually, and certainly the hearings were done virtually when they were wage hearings for obvious reasons, for the protocol set up for distancing and the like. We're going to see a transitioning back to hopefully we're in a post-COVID era where going back to in-person hearings, but we're certainly starting to see more of the inspections in person, and we're also seeing the Department of Labor going back out again and doing more training sessions, which is a good thing. In fact, I talked to Lexi Rojas, who's the new wage and hour administrator after Michelle Small retired, and she said they're anxious to do more and more. In fact, they just did a few this week. So, which is a good thing for employers to understand the perspectives of the Department of Labor. But this program is going to be focusing on issues related to things that we've seen in the last year and the fiscal year of 2022, which ended June 30th, but we can also talk about activities since June 30th this year. But the issue I want to raise with regard to COVID is a lot of employers, many of you perhaps, were anxious to fill positions or just keep the lights on. And as a result, perhaps you didn't focus as you did before on compliance. At least we're seeing a lot of employers that didn't do that, whether it's youth employment certificates or pay notifications for new employees, or your safety plan being updated, or you couldn't fill slots, so you You hired independent contractors when they perhaps should have been classified as employees. Those types of things where, there was some grace applied by the inspectors of the Department of Labor, because we were all just trying to, again, keep our organizations up and running. That being said, there are still violations, and we'll talk about that, because those violations can have pretty significant consequences for employers, disruptive to the employer, but also expensive. So let's talk about that. So the first thing is wage claims. As you know, a wage claim can be filed by an employee or a former employee against his or her employer based upon a claim that there are unpaid wages. And those unpaid wages can be everything from regular hourly wages to salary, to overtime, to claims for unpaid leave time if the employee believes it was due, and other claims as well, but commissions, bonuses, and so on. So when does the employee have to file? Well, there's a statute of limitation in New Hampshire for up to 3 years. An individual has the time to file a claim against his or her employer. So once a wage claim is filed, the employer receives a copy of it. The employer gets to respond to that, either paying the claim or objecting to it. But it's almost automatic. When you object, then you have a hearing. In fiscal 22, again, July 1 of 21 to June 30 of 22, there were 534 wage claims filed in New Hampshire by individuals against their employers. And again, those are separate from wage inspections done by an inspector at your workplace requesting documents. These are individual wage claims filed by current and former employees against their employer. And the results of those are, there's a decision. And when the decision is made, the Department of Labor hearings officer, based upon a review of the evidence, testimony, and documents, makes a decision whether or not the claim is valid. If the claim is valid, the claim must be paid with a stated period of time. And there's an appeal process, of course, you can go through. But the danger with a wage claim is, under New Hampshire law, there's a potential for what's called liquidated damages. And that is up to double the amount of the wage claim due, wage that is claimed to be due. So that can be expensive. And if attorney's fees are involved, there is the possibility for the assessment of attorney's fees and so on. So those are serious matters, 534 of them last year, and more of those are in person. But the focus of today's presentation is not on the individual wage claims, although that is important, because an employee can claim that one of the things on our naughty list, if there was a violation, that could result in wages due to the individual. Now, that is one way it can happen. And oftentimes the individual will call the Department of Labor and complain, and they're assisted in filling out a wage claim. Sometimes those calls, however, can result in the inspector getting the call, says, oh, this sounds like a problem at this workplace. It may be one call or maybe several, that then causes the inspectors to come out. Years ago, the inspectors would do sort of regional check-ins to workplaces and do spot audits. That rarely happens anymore. Now it's basically based upon complaints or issues raised by employees or former employees that cause the inspectors to come out and to do a soup to nuts inspection. And why do I say soup to nuts? Because typically they'll come in with a designated, I'm going to focus on overtime issues or I-9 issues, or I'm going to focus, they have their list of things they want to generally cover, but based upon a complaint, that's why they typically come in. But they still have their laundry list of things. Senator Bradley was responsible for a bill that became law a few years ago that said the inspection should be based upon sort of the problem identified by the Department of Labor. And it shouldn't be everything. It should be focused on that issue and any reasonably related issues. That being said, when an inspector comes in, and for those that are interested, by the way, we developed over the last several years an outline for how to handle a U.S. or New Hampshire Department of Labor audit. The key to that I will tell you is, and if you want, contact me offline at jreedy@sheehan.com. I'll send you a copy of that outline. The key for that is basically being cooperative and providing the information requested. Now, that being said, you're not a doormat. You don't have to put up with abuse from an inspector, which I would say rarely happens. But being civil and being respectful and providing the information, that will go a long way in hopefully a good or better result. Does that mean that you'll get the grace that they'll relieve you of all issues on all claims? Certainly not, but it does go a long way. I mean, the inspectors are human, and if you're cooperative, it doesn't look like you're hiding anything, that you're producing the information they want, that usually is helpful. But so the inspectors will be out, and as a result, there could be civil penalties, and I'll talk about that in a second. But the inspectors conducted in that fiscal year 22, 229 on-site inspections for New Hampshire workplaces. That was down significantly from fiscal 21. You think, gosh, during a pandemic, they were out there. Well, actually, they were doing a lot via email and via phone in fiscal 21. They were actually in person for a majority of the inspections in fiscal 22 as the pandemic was waning. But as a result of those audits, whether it's in person or via telephone or email, NHDOL proposes civil penalties where they found violations. And those violations are based upon the type of the violation, the frequency of the violation, and the number of employees involved. And why that's significant is, under the statute, the Department of Labor has reasonably broad discretion in assigning civil penalties. And in that regard, they look at the type of the violation, the employee, and the number of days involved with that violation. And with that, there can be individual violations per employee, per violation, per day. And so without being a math major, you can basically identify the fact that that is likely to be could be an expensive assessment by the Department of Labor, because the fines are as low as $100 per employee per day per violation to as much as $1,500 per employee per violation per day. And that gets expensive fast. So in the past, the Department of Labor provided us with the gross number, the total amount of civil penalties assessed. They don't keep those records anymore because in many ways it doesn't matter. What really matters is the amount that employers actually paid in those civil penalties, and based upon the original assessment. Now, why is there a difference between what they originally assess and what the employer pays? Well, the employer can point out, no, you made an arithmetic error. No, you counted this person as an employee where he or she was not an employee. That was not a violation. We actually provided those documents. There was a misunderstanding or whatever. And that's typically covered during an informal conference at the Department of Labor. That's one that we recommend, that it's done with the wage and hour administrator and the inspector. The employer sits across the table and they provide information, and they also focus on the employer's assurances of compliance going forward. And based upon that, the department routinely reduces the amount of civil penalties. In fiscal 22, that was the total amount collected by the Department of Labor in civil penalties was $275,651. And that was down from the year before. And you think, well, that's not too bad if you spread that over the entire state. But if that's you, in addition to all the other challenges you had during COVID, and with wage inflation, with labor shortages and the like, or just general inflation, that can be a significant amount too, above and beyond. And so that's civil penalties. And you pay that through the Department of Labor. It goes to the state general fund, and that's how that's taken care of. Now, that's the first part of an inspection. The other part of an inspection, and that can be bad enough or difficult enough for an employer, the other part is wage adjustments. Now, what is a wage adjustment? A wage adjustment is the inspector comes in and makes a determination based upon whatever violations they've found. if wages are due, and again, they can go back up to 3 years to make wage assessments. Typically, they don't. They go between 12 and 18 months back to make determinations. Now, that could be a tipped employee. That could be again, an overtime issue. That could be a minimum wage issue, and so on. During fiscal 22, and this is the sticker shock, the wage adjustments flowing from inspections and the ones that were collected and distributed by the New Hampshire Department of Labor, which I'll talk about in a second, totaled $1,234,245.66. So why is that? What am I talking about? How do they distribute it? Well, what they do is they say, here are these list of employees, these are the wages due, and you have to pay them. How do you pay them? It's current and former employees, and you have to mail them out, and you have to provide proof to the Department of Labor that you've actually paid those. Now, why is that significant? In addition to this significant bottom line impact, that's on top of the civil penalties oftentimes. And at that informal conference that I mentioned, typically you have situations where that in order to get the civil penalties reduced, you have to agree and provide proof that you paid the wage assessments or wage adjustments. So that is significant. And so again, combining the two, $1,509,000, 896.66. That's a lot of money. And that's a lot of money, again, coming out of COVID. But even if we were not dealing with the impact of the pandemic, we are dealing with issues related to a significant unfunded liability for employers. By the way, when you pay the wage adjustments, an employee could still make a wage claim. Now, my view of that is if we've paid the wage based upon the wage adjustment, that is should have a significant impact upon any wage claim, saying that, look, there can't be sort of double dipping here, but an employee can still file a wage claim. We've never seen that happen beyond the wage adjustment payment, but it is possible. So that's how we get to the naughty list, because the consequences for, or the potential consequences for, non-compliance are significant, as you can see, and it's just disruptive. And again, if it's your job to make certain that you've complied with, your organization has complied with state law, and then the CEO, CFO turn to you and say, wait a minute, we have to do what? Whether it's changing your policies for purposes of compliance, or changing your policies and having to pay out wage adjustments and civil penalties, it could mean, issues for you in the workplace. And so, and whether it's you or your payroll clerk, or it could be a supervisor, and we can talk about that too. Still, it results in likely the buck stops with you as an HR professional. So that's why we say you better watch out, you better not cry, because the inspectors are coming to town and they're out there. Now, they're not out to get you, but again, they're out to enforce the protective statutes. So here's the top 10 list. We'll get to it. I'm happy to answer any questions. And if you want to talk to me offline, you certainly can as well. But it's the annual top 10 list. This again was provided by our contacts at the Department of Labor, Rudy Ogden, Lexi Rojas, and others. And we have our own little spin on it. And what do I mean by that? Well, we have the actual violation because that's what they provide. We then provide the description of the problem, and then we offer recommendations for avoiding that problem going forward. So here's number 10 for the top 10 list. And when I say worst, I mean most common, and that's what, but it also could be bad as well. This was a common problem, not just under state law, but also under federal law. And it also, I think, was complicated between the two administrations, meaning the Trump and the Biden administrations. And that is that there is a different standard under federal law, or a proposed different standard under federal law for independent contractors. There are many tests, and the many tests are that there's one for unemployment, there is one for workers' comp. There's one for wage and hour under state law. There's also one under the IRS. There's one under EEOC under discrimination laws. There's also one under the FLSA. So they're different tests. And just because you satisfy one test doesn't mean it satisfies the others. That's sort of important. However, there are common elements to all of these tests. Here's the problem. With low unemployment, labor shortages, wage inflation, many employers had difficulty, and I know this is true for all of you, filling positions over the last couple of years. And so some employers turn to engaging the services of whether it's staffing agencies or independent contractors. And this, we're going to focus on independent contractors here. Again, while there are several tests, we're going to focus, this one is RSA 281A, which is a workers' comp test, but it's similar to the wage and hour test as well. But basically that there is a presumption that someone who performs services for you is your employee unless you rebut that presumption by satisfying the elements of the test. That is true for unemployment as well. In the last year, inspectors found that some employers misclassified individuals as independent contractors instead of treating them as employees. Now, the consequences for that are pretty straightforward. If you don't treat someone as an employee, you're not paying them regular wages. You're not following the requirements of the timing for wages, what is included in wages, and certainly you're not paying benefits. There's no workers' comp coverage, no unemployment contributions, and so on. But we're focusing on here just wage and hour benefits and workers' comp coverage. And what can that mean? That can mean significant penalties for the employer. If you didn't pay wages on time, you could have civil penalties. If you didn't pay overtime, you could have wage adjustments. Benefits, if it's unfunded liability for filling in benefits, that could be very significant. And workers' comp, if there's a workers' comp injury and you didn't treat them, your carrier may not pick them up afterwards, and you may have a situation again of an unfunded liability to cover someone's medical expenses. Things you do not want to do. So the recommendation would be to review the independent contractor test under that statute and the LAB or the labor regulation. Discuss this classification with your counsel. And because it is important that you get this right. Again, the presumption is the person is an employee unless they satisfy the independent contractor test. And the Department of Labor will defer in part to a true independent contractor agreement where you've written down the terms of the engagement with the individual, and some courts will defer to that. However, what really governs is the true nature of the relationship, the day-to-day experiences, and whether those experiences, the relationship you have with that individual, satisfy the test of independent contractor. And it's important to note that neither the person's request, I prefer to be an independent contractor. And there was a survey that came out recently, and this is, again, I think a function of what's happening in the economy. A significant number of people in our economy have a second job. Well, some of those people don't want to pay taxes, or they don't want to have any record that they're performing a second job. So they make a request, treat me as an independent contractor, 1099 me, or pay me under the table. Just because the person requests that doesn't satisfy the test. Or the excuse you couldn't find employees, or you've always done it that way. We've always treated people this way. None of those carry any weight under law. So that's number 10 on the list, and that is one to watch out for. And the Department of Labor found more of those last year than they had the year before. Number 9 is failure to have a written safety plan, a joint loss management committee, and posting quarterly records for that, or a safety summary plan. And it used to be with for employers that had as few as 5 employees, you had to have a test, submit your plan to the Department of Labor. Now it's 15 or more employees, and even then you have to provide updates as needed. That said, you still have to have your safety committee comprised of both management and rank and file employees, meeting quarterly, having minutes of those, posting those notes, and so on. And so what are we talking about? It's similar to the OSHA 300 report, but it's not the same. But it's workplace safety issues, and what have you done to address them? Known hazards based upon individual accidents or bigger issues, and what have you done to address those issues? That's effectively your plan. A common question that came up in the last 2 years is whether or not COVID issues in the workplace, meaning known COVID exposure and what you've done to address those issues with screening and otherwise your policies. Did that need to be addressed in the plan? And the short answer was yes. That inspectors were looking for that as well. But the reason why there's an issue here is that a lot of employers took their eye off the ball with regard to these things. And again, for good reason, focused on other more pressing issues. But the importance of getting your safety plan filed with the department as needed, again, if you've got 15 or more employees. And that's what the recommendation is. And you can file it electronically. That is something that's different in the last few years, but you want to make sure that your safety committee is organized. They hold regular quarterly meetings. They post the meeting minutes, and upon request, they have to produce those to an inspector. Number 8 is paying later than the designated payday. Believe it or not, this is a feature we see almost every year in the top 10 list. And it's employers need to make sure a couple of things, that the deductions or any withholding from the state statute we're talking about, and that would be under RSA 275-48, not 43, but 43 is basically you pay on time. And where does this typically come up? This typically comes up when an employer doesn't pay all the wages due within 8 days from the end of the pay period on which the person performed the services. And when does that typically come up? Say your payroll closes on a Monday and the employee didn't work on Monday, and they came back on Tuesday and said, oh, by the way, this weekend I did this amount. I forgot to put this additional time in. Technically, under the statute, that has to be paid. If you say, well, the payroll's closed, you'll have to wait till the next payroll. Technically, the Department of Labor says you have to issue a manual check for those additional wages and make the proper withholdings for those for taxes and so on. And can you wait till next payroll? It's recommended you don't do that, that you cut the check, but you can deal with an employee saying, you need to record all of your time and get it in on time. Be careful about disciplining employees in that regard too, because it may have been an issue with your system. And again, you have to pay them all wages due within 8 days of the period in which the person earns the wage. The second part of that is failure to pay all the amount due because of unauthorized deductions. And what are we talking about there? Well, what we're talking about there is RSA 275-48, and you'll see a long list there. In fact, there are 12 subparts to that about for the reasons why an employer can withhold from wages. And you have to fit within one of those reasons and follow, to the extent that there are elements within that, you have to follow those as well. And what does that mean? That means that by way of a legitimate loan from an employer to an employee, you have to say, here's the amount due. This is how much we're going to pay, take from your paycheck. The employee has to agree to it, and you have to agree about, deductions for final wages as well. Accidental overpayment of wages, tuition payments, things of that nature, wage garnishments. It's all laid out in the statute, and you have to fit within those. If you do not, then you've got an improper withholding from wages. You haven't paid all the wages due. So it is careful. You have to be very careful in that regard to pay the employee all the wages that he or she is due. Now, there was an important amendment back in 2011 to that statute, which was sort of a catch-all. And I think it's the 12th element in that, which basically is if the employer and employee agree on a withholding and it doesn't benefit the employer, then it's a catch-all, but it has to be for the benefit of the employee, not the employer. This is a big one, working without parental permission. And what do we mean? We don't mean all employees, obviously. This is a youth employment issue. And I think that this again was attributable largely, and this is under RSA 276A 5, and this is the youth employment statute. But under the FLSA, under federal law and under state law, the inspectors take this very seriously, because we're talking about youth, say 15 to 17, working for your workplace, and they're not the most sophisticated employees, and we don't want them taken advantage of. Again, the youth employment standards are very strict, and it goes back to the the genesis of wage law. where it was to protect employers from taking advantage of younger workers. So what are we talking about here? We're talking about youth certificates for employees from 12 to 15. And I venture a guess, while some of you may have hired employees around age 15, I'm certain nobody's hiring 12, 13, and 14-year-olds. But those require, it's a youth certificate that has to be filled out and presented back to the employer. And basically that is dealing with the academic issues that the school signs off that the individual can be working. But that's only part of it. The other part of it is, again, that's for youth 12 to 15. In addition to that, you have to have a parental permission slip. Now, this is what I'm focusing on here. The parental permission slip is a form required that at the time before an employee commences work, a youth employee commences work, 15, 16, 17, you've got this, and that's what I'm focusing on, because that's typically you typically will not go younger than 15. 15, 16, 17, you have to have a completed permission slip by a parent or guardian submitted to the employer, completely filled out. Copy is kept in the personnel file before the individual commences any work, including training for the employer. The problem we found during COVID was employers were hiring younger people than they otherwise would have, and they weren't used to the rigors of and the requirements of the youth employment statutes. What are we talking about there? In addition to the parental permission slip, which is very important that it be completely filled out by a parent or guardian, we're also talking about the hours of work, the days of work, and the types of work. Types of work being very important for the younger workers. And there are restrictions in the statute as to the types of work they can perform. And again, typically meaning not hazardous work, but also the days of work depend upon whether it's in school or not in school. The hours of work depend upon, again, whether in school or not, or on vacation. And a question always comes up, well, what about the homeschooled student? Do the standard hours apply? Yes, for that school district, whatever the standard hours are, and also the schedule, vacation or not, that's what applies to the homeschooler. So the recommendation there is strictly comply, and not just sort of, but strictly comply with the requirements. Again, the types of work, the hours of work, the days of work, and the conditions of work, and certainly having the parental permission slips in place before the youth employee commences any work at all. Now, another recommendation from the Department of Labor is for training your supervisors on the hours of work and days of work. And perhaps on their name badges, meaning the employees' name badges, you've got different color codes based upon their age, because there are restrictions on for 15-year-olds, 16-year-olds, and 17-year-olds in the hours of work and the days of work. And there's a maximum on that. And so based upon that, if a youth worker drifts over even by a few minutes, there's a violation. So you want to make certain that, no later than 15 minutes before the end of a shift, the cap of the time that they're supposed to be working in that day and in that work week, that the supervisor then calls the employee to stop work, and in fact work does stop. That 15-minute cushion is helpful too, for depending on the size of the business and the activity going on, that you don't run over in the time, because again, just a few minutes can result in a civil penalty and potential wage adjustments. Failure to pay all wages due for hours worked, including paid short breaks, overtime, shift differentials, and fringe benefits due. This is RSA 275-43 and LAB 803-01. In other words, timekeeping for short breaks, meal breaks, and reporting time, and failure to comply with those usually results in someone not being paid all the wages due for the time worked. What is a short break? A short break is, under the FLSA, which the state law adopts for purposes of a standard, any break shorter than 20 minutes in duration is considered to be continuous work, meaning you have to pay for short breaks. Does that include meal breaks? Well, as you know, a meal break under New Hampshire law is an employer permits an employee after 5 consecutive hours of work in a workday to have at least a 30-minute meal break, which is unpaid unless the employer permits the person to work at their workstation. And the break, if the break is less than 20 minutes in duration, meaning it's a 30-minute break, but during that time, the person is interrupted or is actually performing work. So if they don't get at least 20 minutes of solitude or relief from working, the entire period must be paid. So that's true for short breaks, that's true for meal breaks, and that is true for reporting time, which I'm going to talk about in a second. Reporting time is a separate statute which deals with if you require an employee to come into work and there is no work for them, and that happens a lot during the winter season, or if there's a power outage, or there's a census issue in the workplace where the person's not needed, you have to pay a minimum of 2 hours at that person's regular rate, or send them or put them to work doing something else during that time. The bottom line here is paying all wages due for hours worked, and so whatever those hours are. And again, the issue here is the employee keeps the record, but it's the employer's obligation to make sure those records are accurate, meaning the time records. And again, that is the time that you look at when the day starts and when the day stops, meaning the workday. And that was a bit complicated too by COVID. But it means from the time that work commences at the beginning of the workday, not their schedule, but the actual time where they actually commence work for the benefit of the employer, and the end of the workday when they stop work for the benefit of the employer. And subtracted out of that any bona fide breaks greater than 20 minutes in duration, where they were not performing any work for the employer. And it has to be, again, that record is kept daily by the employee, and it has to be accurate. It can't be, well, my schedule is 8 to 4, so I'm just going to put down 8 to 4 every day. Well, if in fact that is not accurate, that you know, if it started at 7:53 and ended at 4:05, that's the record. The other issue is, and again, this is a COVID related issue, when employees were working remotely. I mean, I'm talking about hourly and salaried non-exempt employees who were working remotely. Either with authorization or without authorization, they were responding to emails or texts or doing stuff on their own. That's compensable time. And so employers need to sort of make sure they keep track of that, and employees record that time. And again, the problem is an employee can make a wage claim up to 3 years from the time in which they perform that work. So encouraging employees not to work off the clock, or if they are working off the clock, supervisors paying attention to that and making certain that the employees are receive compensation for time performed after the workday, after the regular schedule. So again, that goes to accurate record keeping for hours worked. Failure to pay, this is the reporting time one. Failure to pay 2 hours minimum pay at the employee's regular rate given on a given day when the employee reports to work at the request of the employer and work isn't available. Now, there are exceptions to that. If the person goes home because of their illness or a family emergency, then you don't have to pay them. But the statute here, or the history of the statute was the traditional workplace when the employer said, you're required to come to work, and we need you to come to work, and you get there and they say, oops, we really don't have any work, or you look around and don't need that many people there, or again, there's a power outage or whatever the issue is. And if that's the case, the employer says, I don't need you, then you have to pay the person because they had an expectation of working more than 2 hours, perhaps as much as 8 hours, but the statute says you have to pay them at least 2 hours or put them to work doing something else. The issue here, and the reason why this is on the list, was one, again, employers were not paying much attention to the 2-hour reporting time, but also the Department of Labor's position with regard to what I would say is something that the statute did not anticipate, and that was remote work. What if the employee was in the workplace and then went home and went online and did a training session or did paperwork associated with his or her job after hours? The Department of Labor took the position that if they're performing that work for the benefit of the employer, that's compensable time, And it could be a minimum of 2 hours. Now, I disagree with that. The view is this, rather the statute is, if you are requiring them to come into work. Now, an employer can also stop that by saying they notify them and say, don't come to work. If the person still shows up, technically you're supposed to pay them. Say, well, I never got your message. I never got your text. But take that to remote work for a second. In the case of remote work, the question is that the person's regular job? Because the statute says if if the person's regular job, and they know at the time that they're hired, is going to be less than 2 hours. And the example that's sometimes given is, my job is to go in to check the boiler to make sure it's working. Well, that's going to take less than 2 hours, so you get paid just for the time spent doing the work. But applying that to, so I know my job is regularly 8 hours in a day, and I come in and I perform that 8 hours worth of work. Then I go home and I do some more paperwork. Well, you don't get paid for 2 hours. You get paid for the actual time in which you're performing that paperwork, or logging onto a training session, or things of that nature. So, and again, going back to the example before, the employee has to record the amount of time he or she spends on doing that extra work, and should be compensated within 8 days from the close of that pay period. And you have to monitor that too, again, for overtime purposes. But for the purposes of the 2 hour minimum, that was designed for people actually reporting to work and no work there. Performing extra work and performing or things at your own election for the benefit of the employer is compensable time, but doesn't fit within the 2 hour minimum. Now, we were successful in making that argument with the Department of Labor, and it was agreed that perhaps the statute should address that as well, with more and more employees working remotely. Stay tuned for that one, but that is one that we are working on. Undocumented workers, and this comes up a lot with employers saying, well, wait a minute, I-9s, that's a federal thing under the federal statute and enforced by USCIS. It's not enforced by the state of New Hampshire. It certainly is, and it's under the Citizens Job Protection Act, RSA 275A. In other words, when an inspector comes into the workplace, he or she can say, I need to see your I-9s, and to the extent you keep the support information that you verify in Section 3 of the I-9, I'd like to see that support information as well. Now, again, are you required to keep that support information? You are not. However, more and more employers do indeed keep that, again, off of the A list or off the B and C list on the I-9 form, showing that I looked at a document, it appeared genuine on its face, and to remove all doubt, I kept a copy of it. The Department of Labor can and will look at that. I will tell you that, in fact, I've got a case going right now where those were not readily available, and the employer was hit with 40 violations of that particular statute. So, and why is this an issue? It's a COVID-related issue, or typically because again, a lot of employers were rushed to hire people, and onboarding was quick. Sometimes it was virtual, and the documents were not in place at the time the employee was hired. There's a standard that talks about, within 3 days of the employee working there. That's only if the documents cannot be located. You really should have the I-9 and support documents in place before the person commences work. Again, you want to make certain that you've got these things online, and if you use E-Verify, you still have to have some level of support documents that you keep on file. And number 2 is the written notification of wage rate. What is that? In New Hampshire, under RSA 275-49 and the related labor regulation, an employer must have this paperwork in place at the time someone is hired. And what are we talking about? We're talking about a written notification. And is email sufficient? Yes, but you have to have a copy of that document in the file. And it must be, and it must be initialed by the employee or acknowledged receipt by the employee, and not just a automatic notification. Yes, I received this. It must be something that shows the person actually received it. It's not an agreement. It's not a contract. It just has these very simple terms. The pay rate for the job, hourly, salary, whatever it is, the pay day, the pay period, and a general description of fringe benefits. That must be in place at the time the person is hired. It also must be in place, that written notification, in advance of any changes to those arrangements, pay rate, pay day, pay period, or general description of fringe benefits. Now, general description of fringe benefits, I'll take that one first. That is, you don't have to list all the things under your health insurance plan, your short-term disability, your long-term disability, and so on. You just have to simply say, as a full-time employee, you're eligible for these general benefits, which can change from time to time, and you do not have to have any specific written notification in advance of those changes. It only really gets to eligibility that you'd have to have a written notification of change. But otherwise, you can say, go to the employee handbook, talk to HR, and for more information with regard to those benefit plans. However, you do need to be specific about the pay rate. Weekly salary of X, biweekly salary of X, the pay day, again, the pay period, weekly or biweekly are permitted by the statute. You don't have to any specific permission from the Department of Labor. However, if you do greater than biweekly and no more than monthly, that has to be approved by the Department of Labor. So pay rate, pay date, pay period in writing at the time hired, along with general description of fringe benefits, and in advance of any change thereto. What are we talking about? Someone gets a pay raise, or you change your pay period. You notify the employees in advance of the effective date of that change. And that really is it. But you have to have copies of those documents in the file. If you do not, it's a violation with the Department of Labor. Likely will not result in wage adjustments, but will likely result in a civil penalty if you don't have that. Failure to keep accurate record of all hours worked. That is, again, not recording meal breaks and paying for breaks less than 20 minutes. So one was not paying for it on the list. This one is not keeping the accurate records. So one could result in wage adjustments. This one likely would be a violation because you didn't keep the record properly. And if you stop the clock for a meal break when it's not appropriate to stop the clock, meaning the meal break is not at least 20 minutes in duration. Again, the statute talks about 30 minutes, but you have to have at least 20 minutes of solitude for any type of break. And you cannot cobble together, by the way, well, she took 15 minutes here, 12 minutes there, 18 minutes there, and therefore it adds up. You can't do that. Each break has to be at least 20 minutes in duration. Otherwise, it's considered to be compensable or paid as hours worked. And do they care? The Department of Labor care if you're eating lunch? This is not a nutrition statute. This is basically a workplace safety issue about taking a meal break. Can you have an unpaid meal break waiver? Yes, and on the Department of Labor website, they have a waiver where this typically it would come up if the person's work shift is, say, 6 hours. Well, after 5 hours, I'm not taking a 30-minute unpaid meal break and extending my day without getting paid. Or what if you have a 12-hour shift? So I've got, after 5 hours, I get a meal break. After another 5 hours, I get a meal break. Well, I don't want to. I don't want to extend my day. I'm working long enough as it is. I'll waive the second one. But that has to be on file in the employee's file. And the employee must have the opportunity to say, on this particular day, I am taking a meal break. And that has to be recorded on their file, in the time record, rather. And again, the Department of Labor will take a look, and they'll go back 12 to 18 months. And you want to make certain that those time records are accurate. And be careful about those automatic deductions. Under the statute, you could not have an automatic meal break deduction, meaning after hour 5, automatically a 30-minute block is simply taken out of someone's payroll. That's, again, not an accurate record of hours worked, because it maybe after 5 hours and 20 minutes, or maybe at the 6th hour. And it may not be for a full 30 minutes. It must be the employee clocking out specifically when that work ends and when work recommences at the beginning and end of that break. So that's short breaks and also meal breaks, but it's an accurate record of hours worked. And the number one worst or most common violation from 2022, and this was a bit of a head scratcher, and this is one that could be extremely expensive for employers. Failure to report or obtain a workers' compensation policy. And you say, but this is a wage and hour claim. This is a wage and hour inspection, a top 10 list of wage and hour violations. The inspectors from the Department of Labor will look to see if it's on their inspection list, if you have a workers' compensation policy. Remember, for employers with at least one employee in New Hampshire, you have to have a workers' compensation policy that may be self-funded. Likely it's not. Likely it's under an insurance policy, but you have to have it. You have to provide information to the Department of Labor that you have the insurance and it has not lapsed. If you don't have that insurance and an employee is injured, you could be responsible, meaning you, the employer, could be responsible for the person's medical expenses and potentially their lost wages. That's something you do not want to be involved in, and it can be extremely expensive and actually could break the back of any employer. So the recommendation is really, it's on your management checklist to be certain that if you've got one or more employees, you've got workers' comp coverage, the premiums are paid, and therefore the policy does not lapse. And you also want to look at the coverage issues in the policy and how that's applied and what you have to do for purposes of first report of injury, how you might take advantage of the second injury fund, and so on. So there's a lot there to unpack. Some of these things are perennial favorites. We see them on the list every year. They just shift from their position on the list. Others are brand new. The important thing I think to mention is that the Department of Labor is out there. They're enforcing these youth protective statutes. They're enforcing overtime. They're enforcing workplace safety, and the wages due to employees. And they are focused on the technical requirements of the statute. And therefore, you must be focused on the technical elements of the statute and comply strictly with them. If there's no good in arguing with the inspectors, saying this is ridiculous, you're out to get us, and so on. They're just doing their job. They're just doing their job to enforce, again, these statutes. And there are opportunities during the inspection. And again, reach out to me if you would like a copy of tips on how to handle an inspection. I'll gladly send that to you. No salesman will call. It's a free service, educational service. So if you'd like that, just contact me at jreedy@sheehan.com. I'll send it off to you. And you can use that for U.S. Department of Labor or New Hampshire Department of Labor. You don't provide that to the inspector, by the way. That's your cheat sheet for how to handle the inspection. But again, if you're visited by an inspector, try to be courteous, kind, respectful, and cooperative. Provide the information needed. Consult with your legal counsel on some of these issues if you can, and do it in advance. Because once the inspector's in and once they found the violations, it gets a bit more difficult to undo that. You could have an informal conference at the Department of Labor, which helps reduce the civil penalties. That's important. But remember that if there are wage adjustments, they typically do not reduce the wage adjustments because unless there's an arithmetic error or other errors in the calculation. The bottom line is the bottom line. Again, in the last fiscal year, we saw $1.5 million in civil penalties and wage adjustments, and that's a lot of money. Even if it breaks down to your workplace as little as, a few to several $1,000s, that can be something that you did not plan on. It's something that might be a tipping point for your organization. So hopefully that's been helpful. I do see we've got some questions, and if I can get to the questions here, I'll answer them to the best I can. Let me go to the very top here. Can I share the links and information on the independent contractor test? Yes, I can. It's under the statute that I referenced in the top 10 list. I'll provide additional information as well. But you want to look at, for unemployment, it's RSA 282A 9 Roman 3 ABC. How about that? That's for unemployment. I gave you the workers' comp statute, and that basically is the same for test for wage and hour. You have a new proposed test from the U.S. Department of Labor that is still in the rulemaking stage, but that goes back to the pre-Trump era, before Trump administration relaxed standards for independent contractors. It goes back to the Obama and Bush era test for independent contractors under the FLSA. And again, remember the IRS has its own test as well. Another question is, what if a company pays an employee special sick time for COVID positive absences? Is that considered to be all wages due, or could it be paid late? That's interesting. So that would be if it is a wage that was effectively earned during the pay period, technically it would be due within 8 days of the pay period in which the person was out sick because of the COVID positive absence. So I would probably try to pay that in the next regular payroll. I can't think of a reason why that would be paid late, because you're going to know why the person's out for the COVID positive reasons, like any other sick pay. So try to make that within the 8 days if you can. We have an employee who that went and got a DOT med card for us. He left the job site, went to the clinic, got the med card, and never returned. Interesting. So the employee left the work site at your request to get something, and went to the clinic, got the med card, and never returned. So when does the clock stop? Well, you directed them to do it's a preliminary, post-preliminary, or job-related activity. You send them to someplace. So I would argue that that's compensable time up to the point that they got the med card, and at that point, when they never returned, like Charlie of the MTA, that's when the clock stops. Let's see. Can we deduct the cost of a med card out of his paycheck, or would he have to sign giving us permission? I'm not certain of that one. Again, you go to the list RSA 275-48 and the list of permitted deductions. I'm not certain how a med card would fit into that one. Next one is, what if an employee has an approved ADA accommodation for additional lactation breaks? Can they be unpaid even if it's less than 20 minutes? Well, so the FLSA was amended with the Affordable Care Act to provide for lactation breaks. And I think you want to, it probably is not an ADA accommodation. It's probably a accommodation under the Affordable Care Act, and also under, in our case, would be also state statute as well, for purposes of providing a break. And again, there are elements to it. It's a separate room. It's not a restroom. It's one where there's privacy, locked door, a fridge for the breast milk, and so on. And can that be unpaid? Well, if that break is less than 20 minutes in duration, that's compensable time. If it's greater than that, I would question about how much greater than that. You don't want to penalize a person, especially if they have to travel a distance to get to the lactation break room. What if an employee needed to come to be cleared by the nurse after COVID isolation? Does that need to be paid at the 2-hour minimum? Well, that's not a part of the person's job. That would be fitting within, I think, the preliminary, post-preliminary activity. Is it related to the primary function of the job? And this is a screening issue where they're cleared by a nurse after COVID isolation. I would pay for the actual time. It's treated like a medical exam, I would assume, and you're treating just the time into cleared or not cleared. And I would say the 2-hour minimum probably does not apply there. Does the 2-hour minimum, boy, people are stuck on this one, apply if an employee takes an unplanned work call after hours? No, I think I answered that one. I think the answer is, if it's an unplanned work call after work hours, it's actually for the actual time worked, not the 2-hour minimum. Same question, but when the person is on call and getting paid a stipend to be on call. On call is different, because actually receiving a stipend to be available And then they only receive the actual time worked when they actually commence work. The 2-hour minimum does not apply there either. If an employee reports to work and does not punch in due to no power during the regular shift, and the employer sends the employee home, does the employer have to pay the 2-hour minimum? Well, yes, that's the situation where they report to work at the employer's request. There's no power during their regular shift and the employer sends them home. Does the employer have to pay the 2-hour minimum? Absolutely. Unless the employer puts the person to work, or unless the person's job, and the person knows this at the time they were hired, requires less than 2 hours of work. If that's the case, you pay less, whatever the actual time is. But in this instance, the one you described, you would actually pay the employee the 2-hour minimum, unless you put the person to work that day. I have an exempt employee starting in mid-January, and this person is attending a full retreat day prior to a start date. Are we required to pay the individual? So you've got a salaried exempt employee doing a full day retreat. Now, remember, the salary statute is RSA 275-43B, and it says that a predetermined amount for a fixed period of time, fixed amount for a predetermined period of time, you pay that salary without regard to quality or quantity of work. Now, there are exceptions, like the person quits before the end of the pay period, that they start work after the beginning of the pay period when you can prorate, and there are a few others as well. Here, though, you're talking about a person performing what I would argue is compensable work, attending a full day retreat prior to the start date. The way in which you would do that, however, would be, say, that's the person, that full day retreat hopefully is near the end of a pay period, so you can prorate it to just the days remaining in that pay period, or you do it at the beginning of the pay period, and then the person commences work the next day or the day after. Again, they're performing some work within the pay period, and they're paid for the entire pay period. So again, if you can do that retreat close to the end of a pay period, then you can prorate it to just those few days. But it is compensable time. When across the board bonuses are given to all staff and the same dollar amount, and staff are notified, do staff need to acknowledge in writing prior to the payout? So that would be the pay notification under RSA 275-49. The question is whether or not there's a change in the notification record that they received before, and do they have to receive something in advance? So your pay rate is X. Now, if you mention the possibility of bonuses in there, discretionary and non-discretionary, and it's a sort of a separate issue, but if you mention that, do you have to then give them a subsequent notice? No, I don't think so, but I think you certainly are going to record that they received a bonus, and it's going to be something that shows up on their pay stub. But if it is something unusual that they've never received before, you're not changing their pay rate, you're just paying them a bonus. I still don't think you need to have a written notification of that. It's only if you change whatever their pay notification was, and they're changing it and providing something else. So I think you're fine in that regard. Again, it's going to show up in the pay stub, and you're going to have some communication as to what they're receiving, and then it's going to show up in the pay stub as regular wages and bonus with appropriate deductions and withholdings. Failure to keep accurate hours of work. Are email records acceptable? Employees email their daily and weekly hours in for payroll. Do these need to be printed out and recording? No, I think they just need to be an accurate record of all hours worked. And what we're finding here is, of course, you're getting away from the Flintstone type punch in, punch out. Some employers still have that, but a lot of them use login systems through HRIS. So logging into a portal or an email is acceptable if it is an accurate record of hours worked. That should be, again, on a daily basis for hourly and salaried non-exempt employees. That's who we're talking about, keeping the accurate record of hours worked for. Wow, lots of questions. For at least 2 or 3 years, the Department of Labor was saying that their annual trainings can no longer be used as a waiver that you can't use a waiver for lunch period, but the form remained on the website. Yes, you can still use a lunch waiver. It is still in place. In fact, I attended one of the trainings with Lexi Rojas and Rudy Ogden last month, and they mentioned the waivers. So you can have them. The problem is with that, again, it's not an absolute shield, because if the person takes a meal break and even though they had a waiver, that should be recorded on their time cards. If an employee chooses to skip his or her meal break, do I need to do anything in addition to paying them for that? No. Some inspectors used to say no meal break taken. And so some employers were doing that. So to avoid a violation of no meal break taken. You could also have a supervisor note that the person skipped their meal break. So as long as you have a policy that says employees are permitted to take a break, and you've got scheduling and supervisors are aware of that. I did have a case years ago where the testimony from some employees and former employees was we weren't even allowed bathroom breaks. So you want to have something that says that they were allowed to take the break. Again, it'd be ideal if the person wrote down their time card, whatever form you use for a time card, no meal break taken. And as long as they were paid. Again, the person can still take a short break of less than 20 minutes duration for bathroom breaks or just simple nutrition, getting a cup of coffee, getting water, having a snack, whatever. How could we go about changing our practice of it says coping support, but I assume it's copying support documents for I-9s. Currently, we don't make copies, but would like to start. You just start. You can ask the employee for, and again, it's an original document you're going to be looking at, and you keep a copy of it, and it's secured in a separate file. Still a part of the personnel file, but a separate folder of the document. So you can just start going forward. You don't go back. You can just go forward and do that. And again, my recommendation is you're not required to, but if you're filling out that certification form at the bottom of the I-9, it's a good idea, I think, to show this is what we looked at. I called Department of Labor in 2020 to see if lunch waiver is still required. They said it is not. Do you believe it's still required? My view is, again, an inspector could come in 2 years from now and say, based upon complaints I had, you didn't allow employees time for a meal break. And like I said, you might have that second meal break in a long shift. So my view would be, it's not a bad idea to have either a meal waiver or something that says no lunch taken. If an audit for documented pay change shows up that there was not a written notification in their file going back a few years, what's the best way to rectify this? I actually have this going on right now with the Department of Labor, and the requirement is that what we were agreed to in the resolution of this matter was for the current employees during that inspection period, providing a replacement document. And again, you're not backdating it, you're saying it's a replacement document that shows what their wage rate was at the time that they were hired, and putting that back in their personnel file and have the employee acknowledge receipt of that. And if there have been subsequent pay increases, you show those notifications as well. It's kind of a pain, but it's a good thing. And that would be a part of your HR audit, that you're filling that stuff out and showing that you, again, it could be a COVID-related lapse in collecting that information, but it's not a bad idea to go back and do that. But certainly going forward, if you haven't done it before, start doing it now. Pay notification at the time of hire. For the 8 days after the pay period at the end of the pay date, is that based upon business days or calendar days? That is based on calendar days. So if you 8 days within the calendar following the end of the pay period in which the wages were earned. Is it acceptable to cover pay dates, pay periods, fringe benefits, etc. in an employee handbook that we have the employee sign off on? That's a tougher one. It might be acceptable depending upon the handbook, but my view would be, I think you should have a standalone notice because the employee is going to sign off on that. Again, because your pay rate is going to be different for each employee. So pay date, pay period, fringe benefits, you could point to the handbook, but why not have it all in one document and it's unique to that employee? And you can still direct that employee to the handbook, but I think you should have a standalone document. How would the Department of Labor view hourly employees that every single day have exact punches when they enter them manually themselves. Again, it's 8 a.m. to 5 p.m., lunch at 12. Would they question the accuracy of this time? I would say probably yes. Unless you have just two employees and they're twins and they synchronize it's like synchronized swimmers, and they put in their timesheet exactly at the same time, and lunch exactly at the same time, and lunch and end of the day exactly at the same time. Yeah, I think they would question the accuracy of those records. And again, that might suggest there is an automatic deductions or automatic time records, and that is something the statute says you cannot have. It must be an accurate record of all hours worked. Late punch or forgotten punches, just to mention that, and that would be that the statute talks about rounding to the nearest quarter hour. Can you have rounding? So rounding to the nearest quarter hour is what we refer to as the 7-minute rule. Technically, it's still supposed to be the actual time commenced and ending workday, and beginning and ending of a work break greater than 20 minutes. But what if the person forgets to punch in? What if they forget to punch out? Can the employer do that? Yes, but the employee must acknowledge the change to their time record by initialing somehow, electronically or otherwise, the actual change to their pay records. If an employee leaves and was eligible for a commission, but the company doesn't get paid by the customer for 3 months or more, do we have to pay the person a commission? Well, the answer is that depends upon your commission plan. There was a case called Galloway versus Chicago Soft in the New Hampshire Supreme Court, and it said basically that employers and employees have to understand the nature of that relationship, whether it's a bonus or it's a commission. How is it earned? Are there any clawbacks or deductions or withholdings from that? When is it due? Meaning here, it's when the customer pays, and how long is it due post termination? And that should be in writing. If it's not in writing, then the employee may get his or her own version of or reasonable expectation as to the commission. So it depends. It depends on what the past practice and hopefully written understanding is with the employee with regard to the commission. Our HRIS system allows us to choose an automatic meal break for hourly employee. I'm concerned that this is an option, but apparently it is not in compliance. Statute says you cannot have an automatic deduction because it is not an accurate record of hours worked. Now, I guess arguably you could if it could be overridden by the employee. Again, going back to the earlier question, however, how do we know if it's precisely at noontime and precisely ending at 12:31? We don't know that. So I think you want to avoid that option if at all possible. HRIS systems are not necessarily tailored to New Hampshire law. Most of those systems are, from coast to coast, and state laws can vary from state to state, of course. Do you need to pay someone if the job expectation is that they are available nights and weekends to come in if it snows? Do you need to pay someone if the job expectation is that they are available nights and weekends to come in if it snows? I think the answer is depending upon the nature. I guess that's a hard one, but depending upon what the nature of the understanding is, and if their job is to come in to do something, I don't know if it's treated as on-call time or actually coming in and performing the job, but if they're supposed to perform the job and they don't, then you don't pay them. But if it's on-call time, you would pay the on-call time, whatever it is. But that one, I guess I'm not clear about. We have an hourly employee who's required to come into the plant every Sunday to check on a machine. The task takes no more than 2 minutes, and we're required to pay 2 hours. Absolutely not. Just have it in writing at the time that the employee commences work, if that's their job, that you make it clear that that's a part of the job, and that's what you're only going to pay them for the actual time worked performing that. Do you have to pay the time that they drive from their home to the plant and the time from the plant back home? No, that's commuting time. And commuting time, generally speaking, is not compensable time. Now, you can pay it if you want to, but the only time would be at the actual hours worked at the plant checking the machine. But again, Department of Labor says make that clear in writing at the time you hire them. Now, what if it's only a part of their job and the rest of their job is something else? Well, you would make that clear. This part of your job, this is what's required, and you're only going to be, we want you to keep track of the time actually spent at the plant doing this or that. And again, you can pay them more if you want to, but your only obligation is the actual time worked in that regard, and the 2-hour minimum would not apply in that case. Are you aware of how grateful we are for your excellent guide? Yeah, thank you so much. That was very nice. That was really not a question. We have employees that do not put in their full hours worked each week. These are salaried employees who will put in 40 hours a week. Mainly, managers do not record anything other than their billable time. As a professional services business, all hours are entered in through our ERP system. Is there a regulation that requires that they enter all their time? Well, the answer there would be, if they're salaried exempt, meaning exempt from overtime, they fit within the white collar FLSA test. No, you can just simply pay them the salary for the pay period. Some employers in that regard will still say, we want your recording time because it's going into a billable system like the one you've described, and also based upon how they might earn or accrue paid leave time, or they use paid leave time. So they're recording that I took half a day here, I took a full day here, and so on. But that's recording benefit time. That's not hours worked. If they're a salaried non-exempt employee, they should be recording their work hours because they're non-exempt. And if they cross the 40-hour threshold, they're eligible for overtime. That's something that's frequently forgotten with salaried employees. But remember, in order to be overtime exempt, you must be salaried and fit within one of the FLSA exemptions. If you're salaried and you do not fit within the FLSA exemptions, then you have to record your hours of work and must be paid overtime for anything above 40 hours in a work week. If breaks and lunch periods are paid, you still need to record these. Again, that goes back to what I said earlier. I still would prefer that you put down no lunch taken, or having a meal waiver in place. What about retro pay increases? Is there something due for an evaluation and increase in July, and the evaluation wasn't done until October, and the increase became retroactive? Is this acceptable? Well, yeah, I mean, you're going to pay it retroactively, but that being said, because you've changed their pay record, again, you're paid X amount, and then after the increase, whether it's retroactive or not, you're going to provide something when that becomes effective. Say you're paying it in October, you're going to say, and by the way, this is retroactive back to July, but you're going to put that in writing. But that would be in October in advance of when you're actually paying that retroactive payment. Should clock-in system have a 7-minute rounding? You could have the 7-minute rounding. It's a rounding, but the statute says it can't be to the detriment of the employee. So at that point, why not just basically have it, you're actually paying on the actual time in, time out? Will there be a recording of this session that we can access afterwards? I was about to get to that. Yes, that will be available. There's a link that our very capable Liz Tezik will be sending to you via email, and also a copy of this presentation. And finally, are employees supposed to sign off on or initial hours worked each week? No, I think you can basically have the employee basically punches in or goes through a portal or enters some email record showing that they have the time in and time out. The only time they need to initial a change would be if you're making an actual change to that record. The employee must initial their understanding and acceptance of that change. Well, I hope that was helpful. Lots of questions, lots of very good questions, and I've lost my ability to advance the screens here. So the next screens that come up and which you will see would be that this session is available for HRCI credits or HR credits. You'll be receiving that as well, and you'll be receiving a copy of the presentation. And I believe there's going to be a link too for the recording. So I hope that was helpful. I wish you guys all the best for a close to this calendar year. My hope that you stay off the naughty list. If you want to contact me offline for the outline on how to handle an audit, I'm happy to do that. I do want to thank, again, Lexi Rojas and Rudy Ogden and Wesley Gardner from the Department of Labor for the information they provided, and Sandy Rolfe and Liz Tezik for their assistance with this program. Thank you so much. Again, the very best for the close of the year and the happy holiday season. Thanks so much.